Good afternoon. That's wonderful. So I am Jasmine Gonzalez-Rose, and I am so honored and privileged to welcome you here to the University of Pittsburgh School of Law Constitution Day. So we have a panel presentation here. It's entitled Equality Redefined, Affirmative Action, Same-Sex Marriage, and Employment Rights in the New Term. Now, if this was me, I'd probably call it something like affirmative action, same-sex marriage, rights, oh my, oh my. And by oh my, what do I mean? I mean, oh my, and oh my, and oh my. I think of myself as pretty even-tempered and not one to swing high and low. But this past term of the Supreme Court, I felt myself going from highs to lows, sometimes within the same opinion. So June 24th, long awaited, the Fisher ruling comes out, Fisher versus University of Texas. Diversity is a compelling state interest in higher education. Wow! Yet wait. The court is demanding a more rigorous judicial scrutiny of such programs. Oh my. Then the next day, June 25th, Shelby County versus Holder. Section 4 of the Voting Rights Act is struck down. The formula to determine which states and local governments that have a history of discrimination in voting no longer is needed to get federal approval before changing their voting rules. That safeguard is gone. Oh my. Then the next day, with the same justice writing for the majority, Justice Kennedy, in the case of U.S. versus Windsor, we see Section 3 of DOMA, the Defense of Marriage Act, is struck down. Now, if a state gives out marriage license to same-sex couples, then the federal government, if they're going to recognize opposite-sex marriages, they need to recognize the same-sex marriages. Oh my! Are we heading towards true marriage and extensive equality for lesbians and gays and those who love people of the same sex? Or was this really a states' rights issue? And as a student and a teacher of civil rights and that history, we know that there's a history of states not necessarily protecting the civil rights of minority groups. Now, one who's so preoccupied with these high-profile cases might not notice that the landscape of employment discrimination has been transformed. Two Title VII cases, Vance versus Ball State University, redefining who is a supervisor, and the University of Texas Southwest Medical Center versus Nassar, heightening the standard of proof in retaliation claims. These two cases from two different university systems, both making it more difficult for people to bring employment discrimination and retaliation claims. What happened this last term? Is this a renewed progressive era where affirmative action is preserved, gay marriage is upheld? Or was there chipping away of equality? How was equality redefined by the U.S. Supreme Court this past term? Now, luckily, to answer these questions, we have an amazing group of speakers today. It's hard to really imagine a better group of people here. Now, I could spend all the time talking about their accomplishments and such, but just by quick introduction, we have Associate Dean for Academic Affairs and Professor of Law, Tony Infante, whose scholarship has focused on tax law and critical tax theory, particularly as it affects lesbians and gay men. Who better to talk about these cases? We have Professor of Law Debbie Brake, who scholarship has examined equality, particularly in the area of gender, who of course teaches constitutional law as well, and has looked at how people challenge statutory law, constitutional law for equality and how that impacts them. And also the Dean and Professor of Law William Carter, whose scholarship has explored constitutional law, political and civil rights, and has a real richness in the area of race law. So they're each going to take about 10 or 15 minutes. Then we'll have discussions and questions. I'm glad to see all of you here. Let's turn it over to our speakers.
Well, good afternoon, everyone. So I have a little bit of a cold, but can everyone hear me in the back? Ben, can you hear me in the back? Everyone can hear me? Okay, good. So I'm going to talk a little bit about the Windsor and the Hollingsworth versus Perry cases. So those are the same-sex marriage cases that the Supreme Court decided this term, and I'll give you a little background about each of them and walk through the opinions a little bit. But then at the end, I'm going to talk to you a little bit about going forward, sort of what do things look like going forward for same-sex couples. So I'm going to talk to you first about the Windsor case. So United States versus Windsor is the case that involved the challenge to Section 3 of the Federal Defense of Marriage Act. Now, just to make sure everyone's kind of working from the same plane, the Federal Defense of Marriage Act has two parts, Section 2, Section 3. Section 2 was not at issue. That's the one that's still around. That's the one that says that one state can refuse to recognize same-sex marriages that are celebrated in another state. The provision that was at issue in the Windsor case was Section 3, which is one that said that the federal government refused to recognize same-sex marriages even if they were celebrated in a state that permitted same-sex couples to marry. And the Windsor case, I think, quite appropriately involved a tax issue, sort of very close to my heart. And that case involved Thea Spire and Edie Windsor. And Thea Spire and Edie Windsor had met in 1963, and so they'd been together for quite a long time. In 1993, so some 30 years later, when New York City allowed people to register as domestic partners, they registered as domestic partners. Then in 2007, when Thea's health was starting to decline, they decided to go to Canada to get married. So they went to Canada, got married, and then returned to New York. And in the case, they said that under New York law, New York would recognize that Canadian marriage and respect that Canadian marriage. Now, Thea eventually did pass away. When Thea passed away, she left a pretty sizable estate, obviously, to Edie, because when she passed away, the estate owed $363,053 of estate tax to the federal government. And the only reason that they owed estate tax to the government, because the entire estate was transferred from Thea to Edie, who under New York law were considered to be married, was because they weren't considered to be married by the federal government. For federal estate tax purposes, when a spouse transfers property to another spouse, there's what's called a marital deduction, and it goes completely free of estate tax. So if Thea had been Theodore, there would have been zero estate tax, zero. But instead, they owed $363,053 in estate tax. So the estate paid the tax and requested a refund. When the IRS denied the refund, they sued. And they sued in federal court, naturally, because it's federal taxes, and challenged the constitutionality of the Federal Defense of Marriage Act under the equal protection guarantee of the Fifth Amendment to the U.S. Constitution. Now, Thea's estate, and it's Windsor versus United States, because Edie was also the executrix of the estate. So Thea's estate through Edie won at both the district court level and in the Second Circuit, and then they went up to the Supreme Court. And naturally, because she won, it wasn't her that was appealing, it was actually the United States that was appealing. And in the Supreme Court, the majority opinion was, Justices Kennedy, Ginsburg, Breyer, Sotomayor, and Kagan, and they addressed basically two questions. One question was whether there was standing on the appeal, because one complicating factor here was that the federal government, the Obama administration, was enforcing the Federal Defense of Marriage Act against Thea's estate, even though the Obama administration had concluded that the Section 3 of the Federal Defense of Marriage Act is actually unconstitutional. So you have the Justice Department basically taking the position that really the court should declare Section 3 unconstitutional, but nonetheless refusing to give Thea's estate back the $363,000. So once they'd been ordered to give the money back, there was a question about whether on appeal there was standing, because they'd, in essence, agreed with the outcome of the lower court opinion. The majority of the court found that there was standing, simply because the federal government had been ordered to pay back money that they were refusing to give back. And the court said that that was as much of a concrete injury as the estate being ordered to pay, being required to pay taxes to the IRS that they didn't think that they owed. So they got over the hurdle of standing relatively quickly. On the merits, the court got into the question of whether Section 3 was unconstitutional. The majority, as Professor Gonzalez-Rose indicated, found that Section 3 of the Defense of Marriage Act was unconstitutional. And they talked, the opinion's a little bit on the muddy side, but they talked some about federalism concerns. They spent some time talking about the fact that historically, questions of marriage have been left to the states. It hasn't really been up to the federal government. In this area, in the tax area, whether people are married or not, we've always, left it to the states to determine whether people are married or not. And this departs significantly from that. So the court seemed to be troubled some by the federalism concerns of overriding state marriage laws. But they said, well, but we don't need to decide whether or not this actually violates the Constitution just because, we're departing from the traditional relationship between the federal government and the states in dealing with marriage. They went on, basically to talk about how this violates the Equal Protection Guarantee, because the Federal Defense of Marriage Act really, they felt, was motivated solely by anti-gay animus. They basically said that the only real explanation for this law was, disapproving of same-sex relationships. And just to give you a couple of quotes from the court, the majority said, DOMA's unusual deviation from the usual tradition of recognizing and accepting state definitions of marriage here operates to deprive same-sex couples of the benefits and responsibilities that come with the federal recognition of their marriages. This is strong evidence of a law having the purpose and effect of disapproval of that class. The avowed purpose and practical effect of the law here in question are to impose a disadvantage, a separate status, and so a stigma upon all who enter into same-sex marriages made lawful by the unquestioned authority of the states. And so they basically, are in essence relying on Romer v. Evans, saying that really the only purpose for this law was to just disapprove of same-sex couples, and that's not a legitimate purpose for a federal law. And one question the court didn't really address was the level of scrutiny that applies to classifications based on sexual orientation. They don't, engage in that type of an analysis at all. Justice Scalia, in his dissent, suggests, and he's probably correct, that they were applying something higher than just the rational basis level of scrutiny. And the court does cite Romer and at one point talk about discriminations of an unusual character requiring especially careful considerations. They were probably engaging in something more of a searching scrutiny. And naturally there were dissenting opinions as well in United States versus Windsor from Roberts, Scalia. Thomas didn't write a separate dissent, but he dissented, and Justice Alito as well. And it was interesting. Justice Roberts basically goes through and gives the roadmap to the people who oppose same-sex marriage for how the 12 ways that you can distinguish the Windsor case and what they expect to be the ensuing challenges to state bans on same-sex marriage, which we saw come quickly here in Pennsylvania. And the first challenge to a state ban on same-sex marriage following Windsor was filed here in Pennsylvania by the ACLU. And so Justice Roberts spends his separate opinion talking about these are the ways that you can distinguish Windsor when it comes time to defend state bans on same-sex marriage. Justice Scalia took a different tack. He took great issue with the court's opinion on the question of standing. He felt they eviscerated the constitutional requirement of standing. But he went through and criticized the majority for, in essence, providing a roadmap to people who want to challenge state bans on same-sex marriage, and even went so far as to take a couple of quotes out and say, look, if you just line out these words and replace them with these words, you can just slap the majority's opinion into a brief and challenge a state same-sex marriage ban, which was quite interesting to see. Justice Alito wrote separately, basically to talk about the question of standing, and then basically, in essence, say that from his perspective, same-sex marriage is a moral or philosophical question, and he would just leave it up to the legislatures to do what they will. So that was the Windsor case. So Windsor striking down Section 3 of the Federal Defense of Marriage Act, considered to be a great stride forward for the LGBT community. But that's only half the story, because the other half of the story is Hollingsworth v. Perry, which was the case about Proposition 8 from California. And we'll see in the end that the two of them work closely together in how they affect the LGBT community going forward. So the Hollingsworth case involved a challenge to Proposition 8. Just to give you a little bit of background on what's going on there in California. So in 2008 in California, the California Supreme Court struck down their state statutory ban on same-sex marriage. So there was a ban in the statutes that said, marriage was only between a man and a woman. The state Supreme Court in California struck that down under the California Constitution. Same-sex couples started to marry. That lasted for just a few months because that November of that same year, it's like about June, I think-ish, to about November, same-sex couples are marrying. November, Proposition 8 gets passed, and that amended the California Constitution to add a ban on same-sex marriage. Same-sex marriages then immediately stop. There was first a state-level challenge to Proposition 8, and in that state challenge to Proposition 8, the California Supreme Court actually turned away a procedural challenge to Proposition 8, but said that Proposition 8 would not affect the marriages of those couples who had been married between the California Supreme Court's decision and the passage of Proposition 8. So there was this group of people who married in the magic window who would still be considered to be married, but no one could get married in California after that. Then that led to the federal court challenge of Proposition 8 on federal constitutional grounds. Now, the district court in the Hollingsworth case found that Proposition 8 was unconstitutional. That then went up to the Ninth Circuit. The Ninth Circuit considered questions of standing, just like the Supreme Court did in the Windsor case, because there was also a complication in the Proposition 8 case in the sense that there the state did not want to defend Proposition 8 either. There was actually the proponents of Proposition 8 who defended the law. And so when they appealed the trial court decision that was adverse to them, the Ninth Circuit considered whether they had standing to appeal that decision. The Ninth Circuit actually sent a question to the California Supreme Court asking them whether they thought the people had the authority to defend Proposition 8. The California Supreme Court said that they thought they did have the authority to defend Proposition 8 in court. Ninth Circuit upheld the district court decision. That then went up to the Supreme Court. The entire Supreme Court decision in the Hollingsworth case is just about standing. Whether or not those proponents of Proposition 8 had the standing to appeal, and the majority decided in that case that they did not, that they didn't have anything more than a generalized grievance, just like anybody else in the state of California who agreed with Proposition 8 in terms of enforcing it. They didn't have any concrete injury that they could point to, and they felt that they, even though they apparently had the authority to defend the state's position, that they just did not have the standing the same way the state of California did, and could, through like the Attorney General of California, defend the statute. So my time is running out, so I want to turn now to talking about things going forward, because the Proposition 8 case, because it was so narrowly decided, which is what people pretty much expected to happen, they basically said, okay, no standing to appeal. No standing to appeal meant that the district court decision stayed. It meant that that striking down of Proposition 8 in California was upheld, and same-sex couples started marrying in California again in July. And that's continued on. But that's had no direct effect on state same-sex marriage bans outside of California, because the Supreme Court didn't reach the question of the constitutionality of the ban in California. So what that leaves us with is kind of the patchwork of state laws that we had before, and now the federal government saying that it will have to recognize same-sex marriages. And that raises, a whole litany of questions and problems for same-sex couples. You're already having to start to keep a scorecard. Only parts of the federal government have come out with their positions. The IRS, Department of Defense, Office of Personnel Management have all come out with positions, and Social Security. Social Security will only their rule for recognizing same-sex marriages goes on the place of residence. So where the couples are resident, because of the statutes that govern the Social Security Administration, which require them to do that. the Office of Personnel Management, IRS, and Department of Defense are using a place of celebration rule. So you're having to keep a scorecard of when to use place of celebration, when are you going to have to use place of residence, and then even beyond that, the IRS guidance, which only came out a couple of weeks ago, is during the first week of classes, is probably the guidance that's the most generally applicable because, well, we all pay taxes. We're not all in the military. We don't all have Social Security benefits, but pretty much all of us file taxes. So we worry about the tax aspects of things. And the place of celebration rule was thought to be, kind of the easiest way of doing things, but it's got as many problems as the place of residence rule, in part because the IRS doesn't seem to even have thought about the possibility of evasive marriages. So where you say you have somebody from Pennsylvania who goes to New York, gets married, comes back to Pennsylvania. The way the guidance is written, it seems to be all focusing on people who live in a state that recognizes same-sex marriage, marry in a state that recognizes same-sex marriage, and then at some point later on move to a state that doesn't recognize same-sex marriage. And they say, well, we'll use the place of celebration rule. So if you have a Massachusetts couple living in Massachusetts, marry in Massachusetts, a few years later move to Pennsylvania, well, we'll still treat them as married. What they don't seem to talk about is what about people who live in Pennsylvania, cross the border into New York, get married, and then come back to Pennsylvania right after that? How do you deal with their marriages? What law are you going to use for that purpose? There's also some traps for the unwary in dealing with the place of celebration rule. There's been a big problem in terms of divorce for same-sex couples because the residence rules for getting married are pretty lenient. You can just usually go somewhere, get married, and then come home. The rules for getting a divorce are often very different. In some of the states where people can get married, you have to go live there for 6 months or a year before you can file for divorce. So some people who live in a state where, the state won't recognize their marriage find themselves trapped. The state they live in won't recognize their marriage, won't let them get divorced, and it's too onerous to go back to the state where they got married to go live for a year, uproot their whole lives so they can get divorced there. So they're trapped in not being able to get divorced. From a tax perspective, they're not divorced until a court says they're divorced, even if they live apart forever. And then you end up being trapped in what I call the married filing separately trap. You end up married filing separately for the rest of your lives, which is not where you want to be. A very few couples actually file married filing separately voluntarily, and that's in part because the tax rates for married filing separately very quickly get higher than the tax rates for people married filing single or even married filing jointly. There's also limits. You have to follow your former spouse for the rest of their lives, because if your former spouse itemizes their deductions, you are prohibited from taking the standard deduction, as long as you're doing married filing separately. And then there are a bunch of tax benefits that if you're married, you have to file jointly in order to get them. If you file separately, you lose them. So things like education benefits, the deduction for student loan interest, if you don't file jointly, you don't get the benefit. And they don't even get into lower level choice of law questions like, well, what if we're not talking about the Internal Revenue Code mentioning someone's marital status, but where marital status may be relevant? Think, do you have a parent-child relationship? What if you're married in Massachusetts, you live in Massachusetts, and you later move to Pennsylvania and have a child in Pennsylvania? And Pennsylvania's not a good state. You pick a state that doesn't have a second parent adoption, for example. So, you move to a state where you can't have the non-biological parent establish a relationship with the child, but they could have had a relationship in the place where they got married. How do you deal with that? How do you determine who's the child for tax purposes? None of that is addressed in the guidance from the IRS. So there's lots and lots of other questions. Kind of the bottom line is, kind of, oh my, that, you think you're equal, you think you're making a stride forward, and what you realize when you start really thinking about it is that equal is not all that equal. In fact, equal is actually worse than what we were before we were not equal. So, it's an advance in terms of, getting the Section 3 of the Federal Defense of Marriage Act struck down, but the consequences for same-sex couples are going to be difficult for a while.
Good afternoon, everyone. Hi, good afternoon. It's good to see you all. So when I was planning my remarks, as I often try to do in these sort of settings, I was planning to be relatively brief for a couple of reasons. One, you all hear me talk enough, and so my preference is usually to get out of the way and let you hear some of my eminent colleagues talk. And the other reason is that in these kind of things, the part that I find the most stimulating is the audience discussion. So I try to minimize the length of my formal remarks in order to really have a good discussion, dialogue, and debate. In thinking about that, I told our Associate Dean for Research, who's the boss in putting together this program, that I was thinking about being relatively short, and he said, you have to speak for at least 15 minutes due to the CLE requirements. So starting now, I will be speaking for approximately 15 minutes, but I do look forward to the discussion. The only other thing I wanted to say is I appreciate you all being here. Constitution Day is one of my favorite days of the year. I'm a Constitution junkie, and no matter how old and cynical I get, I always retain a certain mystique about the judiciary and about the Constitution, and so it's really a pleasure to have the opportunity to speak with you all about these issues. So in my relatively brief time, I want to try to accomplish three things, all of which I'd be happy to draw out a little bit more during the course of the conversation and the Q&A. First, I want to talk a little bit about the current legal landscape with regard to affirmative action with a nod to the Fisher decision, Fisher versus the University of Texas. Secondly, and it's related in ways that I'll try to explain, I want to talk a bit about the Supreme Court's decision in Shelby County versus Holder, the decision striking down the pre-clearance provision of the Voting Rights Act. And then third, I want to just take a couple of minutes to step back and think about how those two decisions, along with other ones, might speak to the evolving landscape with regard to the law of equality, at least from the Supreme Court. So with that, let's start with affirmative action. So as you know, affirmative action remains a contentious social issue. The original concept of affirmative action, of course, was that in order to combat the legacy of slavery and discrimination, Jim Crow, as well as modern day social inequality, the government should be permitted, and some would say required, to take explicit cognizance of race in order to level the playing field, to use that hackneyed phrase. The other justification traditionally for affirmative action programs, whether in education or elsewhere, has been to promote diversity. The idea that in our workplaces, in our learning environments, and elsewhere, having a greater diversity of viewpoints benefits not just people of color, but also people who receive the benefit of that diversity of viewpoints. It's fair to say that beginning in the late 70s and 80s, the Supreme Court at least began to back away from the commitment that was established earlier to affirmative action programs, at least as traditionally defined. So you get cases like Bakke out of the University of California Medical School striking down their affirmative action program. You also get cases in public contracting, and I'm thinking of a case called Croson as well as Adirond from the late 90s, that demonstrate that the Supreme Court was becoming more cautious and more skeptical about the propriety of the continued use of affirmative action. The blockbuster cases from the early 2000s coming out of the University of Michigan continued and accelerated that trend. Gratz versus Michigan and Grutter. Gratz, the court struck down the University of Michigan's undergraduate affirmative action program, ruling in essence that it was sufficiently rigid that it amounted to a forbidden quota. In Grutter, the court in a 5-4 decision upheld the law school's affirmative action program, and this is important context for Fisher, so I want to go over it briefly. The court's reasoning in Grutter was as follows. First off, the court rejected the idea of remediation or leveling the playing field as being sufficient in its own right to provide a constitutional justification for affirmative action in higher education. That is, the desire to remediate past wrongs not caused by the university itself could not be a compelling state interest, okay? But the Grutter majority held that the diversity rationale indeed could be a compelling state interest, at least in the context of higher education. It ruled that universities occupy a special place in American life, and that they should have some freedom to define the methodologies that best advance their educational mission. If universities believe that having a critical mass of diversity improves learning outcomes, the court held that that can be a compelling governmental interest. The court place some further limits, though, on the use of affirmative action via the narrow tailoring prong, and this is the prong that the decision in Fisher picks up on. The court said that even if diversity can be a compelling governmental interest, your means still have to be narrowly tailored to withstand strict scrutiny. And in order to be narrowly tailored in this context, the court held, you cannot consider race as a determinative factor in its own right. Rather, race is only permissible to be considered if it is one of many factors in a holistic, individualized assessment of each applicant's file. So the same way universities consider legacy status and athletic ability and objective test scores, they could consider race as one such factor as long as it was not determinative in and of itself, okay? So fast forward to Fisher, which came down at the end of the term. So Fisher was the case that folks who followed this field expected to be a blockbuster, right? It had been 10 years since Grutter. All of the signals coming out of the court in cases that were related to this area in the interim were that there was at least a 5-justice majority that would be inclined to end affirmative action programs altogether. That obviously didn't happen. And let me tell you a little bit about the Fisher case itself, and I'll share with you a few highlights from the court's reasoning. So in Fisher, this involved the University of Texas system. The Texas legislature in the 1990s, in response to a decision called Hopwood, had adopted a nominally, or at least facially, race-neutral admissions program in Texas called the Top 10% Plan. Florida, a couple other states adopted plans like this as well. The idea is that graduating high school seniors in the top 10% of their classes would receive automatic admission to any Texas public university. So the University of Texas first employed this race-neutral measure in large part because at this point in the 90s, the permissibility of affirmative action was very much in doubt, okay? The university saw some moderate increase in diversity by virtue of this kind of top 10% plan, but after it had been in effect for several years, they started to notice at least two problems. One problem was that even if there was slightly increased diversity at a macro level in terms of the overall population in the university, that most of, and indeed the predominance of the university's classes themselves had very, very little minority representation in any particular class, okay? So the classrooms did not look that different, and Texas was therefore concerned that the values that diversity would actually bring simply weren't being realized. The other concern was because the top 10% plan had resulted only in a modest increase in diversity, was the social isolation that minority students at the University of Texas expressed they were still feeling. That is, there was not a critical mass, at least the university believed. So what did it do? Well, around 2003, after Grutter came down, the university said, well, hey, the Supreme Court gave universities permission to consider race as one of many factors in a holistic, individualized assessment. Let's do that and see if it leads to any solutions to these problems that we have considered. So from the university's perspective, the plan challenged in Fisher was completely in line with what the Supreme Court had declared to be permissible in Grutter. The University of Texas was sued by a disappointed applicant who claimed that her application was rejected by virtue of the Grutter-style diversity plan combined with the top 10% plan. It goes to the Supreme Court, and the Supreme Court, in something that turned out to not be a blockbuster, but largely a procedural case, vacated and remanded. And the court's reasoning was as follows. The court, this was a 7-1 decision, by the way, which was interesting, with Kagan recused. 7-1 decision, the court held that indeed Grutter remains good law, that universities may still pursue diversity, and that it would qualify as a compelling governmental interest sufficient to withstand strict scrutiny. However, the court wanted to tighten up or ratchet up the second prong of strict scrutiny, that is the narrow tailoring or least restrictive means requirement, okay? The holding was that the Supreme Court believed the Court of Appeals had not applied that prong with sufficient rigor and therefore vacated and sent it back down. So what was the court's reasoning in doing this and taking this procedural approach? There were a variety of outcomes that were possible in this case, right? It could have affirmed in toto what the university had done and what had been upheld by the Court of Appeals. It could have issued a broader ruling holding that affirmative action programs are not permissible. It could have ruled on standing grounds, which is always fascinating to me in these cases. How does Ms. Fisher know that the reason she was rejected was because of these plans? And I had the same question about Ms. Grutter in Grutter versus the University of Michigan. But the court did none of that. What it decided to do was to take a procedural tack, and here's what the court said was flawed with the Court of Appeals reasoning. The court reasoned that the narrow tailoring prong requires a careful judicial inquiry into whether a university could achieve sufficient diversity without using racial classifications. Although narrow tailoring does not require the actual exhaustion of every conceivable race-neutral alternative, strict scrutiny does in fact require a reviewing court to examine with care and not defer to a university's good faith consideration of race-neutral alternatives. Here's what the court is saying. While universities may receive some deference as to the question of whether diversity is essential to their educational mission, that is the compelling interest prong, they should receive no deference as to whether the means chosen to achieve that interest were the only workable alternative. So what the court wants the lower courts to do, both in this case and in later cases, is to more strictly scrutinize the choice of means. The question being asked in the subsequent litigation, and there's going to be a lot of it, is was there sufficient evidence presented that no other workable, administrable, race-neutral alternative would have achieved the university's objectives roughly as well as the consideration of race. Now, if you think about this as a litigator, what this does is it does two things. One, I should have said this at the beginning. I'm speaking as a legal scholar who studies these issues, not as the dean of the University of Pittsburgh School of Law. So saying that for the video. I am not speaking about any programs here. What it does, if you think about this as a litigator, however, is it creates a disincentive for a university and risk-averse general counsel's offices to continue to consider race in a Grutter-style fashion. Why? Because now I have to be able to demonstrate that there was no other race-neutral alternative that was workable that would have achieved the same ends with roughly similar efficacy. How do I actually demonstrate that in litigation? I actually implement and try every conceivable non-racial alternative, right? That's really expensive, number one, requires a lot of personnel time, number two, and number three, may not be worth the candle. That is, universities may simply decide to switch to race-neutral alternatives altogether because of the downside litigation risks. I'm not convinced that that is what is going to happen, but that certainly is one alternative. So the takeaway from Fisher is that I suppose we'll see on the bigger substantive questions as to whether the Supreme Court believes that affirmative action remains permissible. We will see as that works its way through the lower courts. The other case that I wanted to talk about briefly, I knew I could easily speak for 15 minutes, Heider. The other case that I wanted to speak about briefly was Shelby County. That's the Voting Rights Act case, and I'll try to be a little bit briefer here. So the Voting Rights Act of 1965 contains two primary operative sections. Section 2, which authorizes a cause of action for case-by-case litigation challenging voting practices that are alleged to be discriminatory, and Section 5, which was at issue in Shelby County. Section 5 is a kind of prophylactic measure. To use the words from one of the Supreme Court's earlier decisions, Section 5 was designed to put the benefit of time and inertia on the side of the plaintiffs. So what did the Department of Justice learn litigating civil rights cases and voting rights cases one by one in the 1950s and early 60s? The DOJ learned that that was ineffective, right? So you bring a lawsuit challenging a poll tax, the local registrar gets rid of the poll tax and adopts a literacy test. You then bring a second lawsuit challenging the literacy test and they adopt something else. That was not a cost-effective way of combating entrenched discrimination in voting. So Congress decided we need a prophylactic measure, and they came up with Section 5. What Section 5 does is require certain covered jurisdictions, those jurisdictions found to have a prior history of discrimination in voting under the Section 4 formula, which I'll come back to in a moment, to submit for pre-clearance any changes whatsoever to their voting procedures, right? Any change. If you want to move a polling place to another neighborhood, if you want to lengthen or shorten voting hours, if you want to change the color of the paper ballots, any voting change would have to be pre-cleared either by the Department of Justice or by a special 3-judge panel of the DC Circuit. As you can imagine, over time this began to rankle advocates of states' rights. They thought, why should we have to submit such routine changes to federal approval, especially when our country has changed, right? The issues in voting discrimination, the folks on this side would say, are quite real, but they're no longer dogs and fire hoses and beatings and jailings for those who would seek the right to vote. They're more subtle than that. This country has changed, to use the words of Chief Justice Roberts in his majority opinion in this case. And indeed, the Supreme Court agreed that the coverage formula, this is Section 4, which determines how a jurisdiction becomes subject to Section 5, the Supreme Court held was sufficiently outdated that it did not respond to current circumstances in a way that preserved the equal dignity of the states, okay? So in one sense, this is a federalism decision. Why, the Chief Justice would ask, should Alabama be treated different than Pennsylvania with regard to voting discrimination today? Why is it that Pennsylvania does not have to submit its changes to preclearance, whereas Alabama does? That offends the sovereign equal dignity of the states in the majority's opinion. Now, one of the interesting things about this case, in addition to being a federalism decision, is that it is also in some sense a decision about judicial review. Congress did not lightly reauthorize the Voting Rights Act, most recently in 2006. Indeed, to the contrary, it assembled 26,000 pages of testimony attesting to continued discrimination in voting in the covered decisions. It held months of hearings. The act passed the Senate unanimously and passed the House by a near unanimous margin. The Supreme Court, applying a brand of judicial review that is at least worth asking questions about from a perspective of democratic rule, held that that may all be well and true, but that the court would exercise a superior judgment that times have changed sufficiently that even in the face of that evidence, those measures are now not only unnecessary or unwise, but unconstitutional. In Justice Ginsburg's dissent, she had, in my view, an apt phrase. To some extent, that kind of reasoning is like throwing away your umbrella in a rainstorm because you're not getting wet, right? To the extent that in covered jurisdictions, we have seen some decrease in voting discrimination. An alternative reading is that that is due to the continued existence and enforcement of Section 5. So where do we stand with the Voting Rights Act? What the court actually struck down was Section 4, the coverage formula. The coverage formula, which was established in 1965 and carried forward without alteration in the 2006 reauthorization, looks to things like voter turnout in the past 2 or 3 presidential elections, a history of using prohibited devices like literacy tests, poll taxes, etc. It is that provision that the court struck down. It is that provision which Congress is free to reauthorize, thereby resuscitating Section 5. And it is that provision that it seems unlikely that Congress is going to take any action on. Right now, Congress can't even pass a bill saying that the sky was blue today. So it seems unlikely that they will pass a bill specifically to address Section 4, but I've been wrong before. So let me take 2 minutes just to share with you how I think about this case as well as some other cases in the same area. So I see Shelby and Grutter before it, and Fisher as part of a trend that scholars have called post-racialism. I wrote an article about this this year called The Paradox of Political Power. The idea of post-racialism in a nutshell is simply that we believe, some believe, that sufficient racial progress has been made in this country that governmental measures seeking explicitly to redress the remaining inequality are a cure worse than the disease. That is, that all things told, we've made such progress that direct governmental attention to these issues causes resentment and divisiveness and balkanization and threatens social cohesion in a way that the game isn't worth the candle. It causes too much harm. Under this view, our remaining inequality inequalities and inequities will somewhat naturally correct themselves if we continue to make progress at the pace that we have been. Needless to say, many legal scholars, including myself, have called that into question as an empirical matter. But I think cases like Fisher and Shelby County certainly adopt the post-racialist perspective. I'll add just one last thought, and then I will stop talking, because it ties into Associate Dean Infanti's presentation, and it ties into the issue of marriage equality as well as equal rights for lesbians and gays. So you all may remember, if you followed the coverage closely of those two cases, that one of the questions, or statements, I guess, in the form of a question that Chief Justice Roberts made was, why do we need special judicial solicitude these days for gays and lesbians? It seems to me that politicians are tripping all over themselves to stand up for the rights of people who are gay and lesbian. That instinct, that urge to say that sufficient political empowerment has been achieved, that judicial solicitude is no longer necessary, is what has led to the accelerating trend of skepticism toward measures addressing racial equality. Many scholars who think about the newer frontiers of equality suggest that comments like that are indicative that that day is coming in other areas of equality. In other words, the assumption that certain groups have reached a sufficient place of political empowerment that the Caroline Products famous footnote 4 rationale of discrete and insular minorities is no longer applicable. So I'll leave that as food for thought. We will see if these two threads of equality doctrine come together as they seem to be doing, or whether they will remain distinct as they are right now. So thank you for a few minutes, and I look forward to your questions and the discussion.
Good afternoon, everyone, and thank you for sticking with us this long. Hold on for another 20 minutes or so if you can. So the burden of my 15 minutes is to convince you that the two sort of stepsister cases from this blockbuster term that I'm talking about are worth a space on the table for Constitution Day, because I hope by the end of my 15 minutes I can at least convince you that these cases have been overlooked and yet have very important implications for our theme today, which is equality redefined. And both because of their real-world impact on employee equality rights in the workplace and for what they teach us about constitutional structure in our modern civil rights era, I believe they deserve some attention on Constitution Day. So let me just say, as a starting point, in thinking about equality and non-discrimination rights under the Constitution, it is important to remember that there is a very central role played by statutory law, especially at this moment in constitutional history, in realizing the promise of equal rights for all. The Constitution gives us a basic charter of a minimum floor of rights in our democracy, but it leaves many of the details to be fleshed out by Congress. So, since constitutional rights of equal protection, for example, and due process only extend to state actors and not private actors at all, that's a basic principle of constitutional law, federal equality rights that extend to the private sphere have to come from the legislature. And that means in our federal system, Congress using its constitutional powers to create specific guarantees of equality beyond the constitutional minimum. And even as applied to state actors, the way equal protection guarantees under the Constitution have been interpreted by the Supreme Court in what many would call a minimalist fashion, at least as applied to sectors like employment, it is our statutory law today that does the bulk of the real world work in securing equality rights. There's one particular statute in this mix that plays an outsized role, and that is Title VII of the Civil Rights Act of 1964. In 1964, Congress used its constitutional powers under the Commerce Clause, the power to regulate interstate commerce, combined to an extent with Section 5 of the 14th Amendment and the power to enforce the Equal Protection Clause, to reach both public and private employment and ban discrimination on the basis of race, sex, religion, and national origin. Title VII has been called a super statute by one scholar to denote that special realm of those few statutes that have so changed American life and so speak to our ideals of the basic constitutional charter that they play a special role in setting our foundational democratic commitments. That is Title VII. And so Title VII has been a model for other federal statutes, including bans on discrimination on the basis of age and disability, as well as for state discrimination laws. In the structure of government set up by our Constitution, the court applies Congress's statutes in cases that come before it, and this often requires the court to make interpretive choices. This is all the more true with a statute like Title VII that speaks in very broad terms of discrimination, terms that are contestable and historically contingent and can change shape over time. In fact, Congress and the court have been in what could be called a dialogue, some would say a struggle, over the meaning of Title VII in the past couple of decades, really. So the two Title VII cases decided this term really showcase that dialogue, that struggle, and reveal a struggle within the court as well. So the first case is the University of Texas Southwestern Medical Center versus Nassar, which involved the thorny question of what proof burden an employee has to meet to prove unlawful discrimination, unlawful retaliation for complaining about discrimination. So there's a particular section of Title VII that makes it an unlawful employment practice to punish somebody, if you will, for complaining about discrimination. So in this case, the employee was a medical doctor and a medical school professor, identified in the court opinion as being of Middle Eastern descent. We know from the lower court opinions that he went to medical school in Egypt and he identified as a Muslim. And he had challenged what he believed was the university's biased treatment of him on the basis of national origin. And is often the case when you're reading court opinions, you get a completely different picture of what happened to this doctor from the majority opinion as you do from the dissent. Reading the majority opinion, you're left wondering how the jury could have awarded this guy a significant damages award for national origin discrimination, which in fact it did. But then you read Justice Ginsburg's dissent and you're left with a very different picture, a picture that does suggest that in fact Dr. Nassar endured hostile and unwarranted treatment when the supervisor who hired him was replaced by another supervising doctor openly hostile to persons of Middle Eastern descent. And in fact, this person made comments such as that Middle Easterners are lazy, and then exclaiming disappointedly when the hospital hired another doctor of Middle Eastern descent that, well, the hospital went and hired another one. And the comments combined with the unfair and very different treatment that the other doctors received caused Dr. Nassar to believe, not unreasonably, that his national origin had something to do with his supervisor's campaign to push him out. So he tried to restructure his job to get out from under this supervisor, seemed like a reasonable thing to do, to sever his affiliation with the medical school but stay on as an affiliated doctor at the hospital. And the hospital was agreeable to this initially, so Dr. Nassar proceeded to sever that connection. But when he resigned from the medical school, he explained the reason for this as discrimination and harassment. And that was the point where the hospital closed ranks and convinced the hospital, or the university medical school closed ranks, convinced the hospital to sever that affiliation, which the hospital did. And so at that point, he brought his case alleging both the initial national origin discrimination, the campaign to push him out, and also retaliation. He won both of these claims before the jury and got a significant award of damages. The appellate court overturned the discrimination claim, but left intact the retaliation claim. And that's the posture that the case has when it goes up before the Supreme Court. So it's the retaliation claim being reviewed by the court. And here the court said, in overturning the retaliation claim, that that claim should have been sent to the jury under a higher standard of causation. That is, the jury was instructed that they could find for Dr. Nassar if they found the retaliatory motive was a motivating factor. The jury said yes, it was. Well, the Supreme Court said, no, that's the wrong standard. It's not enough to show that it was a motivating factor. The plaintiff has to show that it is the but-for cause, that is, that it is the factor, rebutting the employer's explanation completely. That is a much, much higher proof burden. And the practical import of the court's decision is that it makes it significantly harder for employees to gain legal redress if they suffer retaliation for complaining about discrimination. And this new higher proof model for retaliation claims gives second-class treatment to retaliation claims, backtracking from several precedents from the court's own docket a few years ago, in which the court saw retaliation as inseparable from discrimination, an essential part of the fabric of a non-discrimination statute. And here the court sets off the retaliation claim on a different ship, on a different path, with a few more holes in it than the discrimination claim. So bear with me for a moment, because this is the part of the talk where I get into a little bit of the statutory nuances here. But I find the decision most problematic in terms of the dialogue that the court takes in its relationship with Congress. Because there basically were a couple of options that the court could have gone with in interpreting the statute. And importantly, one was coming from a 1991 amendment to a 1989 Supreme Court decision. With the 1989 Supreme Court decision, the famous Price-Waterhouse decision, setting the groundwork for employees to prevail if they could show that the discriminatory reason was a substantial factor in an unlawful employment decision, a substantial factor, not the but-for cause, just a substantial factor. And then there'd be a defense for the employer to get out of liability if it could show, well, the same decision would be made anyway for a non-discriminatory reason. That's the 1989 model. Well, Congress comes along in 1991 responding to a number of other Supreme Court decisions too, but looks at this case and says, yeah, we like the motivating factor model, but it's not strong enough for the plaintiffs. We're going to make it easier for the employees. We're going to make it a motivating factor, not just a substantial factor. And once the plaintiff shows a motivating factor, they win. Unlawful employment practice. And then it's up to the employer to have a defense only to the remedies. So there were these two things to choose from. The 1989 case that's pretty good, but then Congress's 1991 amendment that makes it even better for the employee. And the Nassar court looks at that and says, neither one of these. It's actually a worse option still, but for causation. And in fact, what happens is Justice Kennedy is writing the opinion at this point in Nassar, and Justice Kennedy had dissented in the Price-Waterhouse model, never liked that light a burden on the employee. And so the court is really, frankly, to put it in layperson's terms, dissing the 1991 Congress that tried to make the proof model stronger for plaintiffs with respect to discrimination claims, and using the oversight of Congress in not amending the retaliation section at the same time that Congress was amending the non-discrimination provision of Title VII. And so the result is to set a much higher bar for proving retaliation claims than employees have in proving non-discrimination claims. And since retaliation is the number one reason why people don't complain about discrimination, and the second largest class of claims being filed under Title VII, this is going to have important repercussions for this very important civil rights statute. Well, the second case I'll try to take a little less time on, but the second case is consistent with this theme of cutting back on workplace equality rights and the court lobbing another volley in this dialogue between the court and Congress. So this case, Vance versus Ball State, involved the thorny question of who counts as a supervisor in our employment discrimination laws. And the answer to that question is important because in harassment cases brought under Title VII, the court has developed a framework for employer liability in a pair of 1999 cases that turns very much on whether you are harassed by a supervisor or a coworker. And by the way, this is true not just for sexual harassment, but all forms of harassment under the statute, including racial harassment, which was at issue in Vance. So under this 1999 framework, if you're harassed by a coworker, you have to prove employer negligence, which is a fairly high standard. But if you're harassed by a supervisor, that is an agent of the employer, there is vicarious liability on the part of the employer for what the supervisor did unless the employer can prove an affirmative defense, that it took reasonable corrective action that the employee failed to take advantage of. So it's a much better standard for the employee for supervisor harassment. So after the Supreme Court settled on this framework, of course, the big question became, well, who's a supervisor? Because actually, it's more complex in the real world. And the EEOC very quickly came out and said a supervisor is someone who exercises day-to-day control over your work environment. And of course, in addition to that, someone who could hire, fire, demote, do pay cuts. And a number of circuit courts went with the EEOC, but some took a tougher tact. And the Supreme Court, in the Vance decision, finally comes down on its answer to that question, siding with the courts that had taken the toughest tack on who is a supervisor. And so the court says it's only someone with the authority to take ultimate employment actions, like firing, demoting, pay cuts, not just someone with day-to-day authority over the workplace. So the upshot of this decision is that the class of cases where employers will be vicariously liable for harassment by supervisors just got much, much smaller. And in many of these cases, the employee will likely be without a legal remedy unless they can prove negligence by the employer. Again, a much tougher standard. So the court's posturing with Congress in the Vance case is a little bit different than it was in the Nassar case, because here the court is not clashing with Congress over a congressional override to a Supreme Court decision the way it was in Nassar. Here, the court is interpreting a word that appears nowhere in the statute, supervisor, a word that came from the court's own prior interpretation of the statute. But nevertheless, the court's narrowing of that term from what many courts and the EEOC had come to understand shows just how much latitude the court has in our constitutional system to fill in the gaps left by congressional statutes. My final point, and then I will close, or leave it to Professor Gonzalez-Rose to open it up for questions. In both of these cases, importantly, 4 justices dissented. These were 5-4 decisions, closely fought. And both of these dissents were led by an embattled Justice Ginsburg at the top of her game. Justice Ginsburg, reading from the bench, took the unusual step of calling on Congress to respond to these decisions. And in both cases, she accused the court of being insensitive to the realities of working life and of substituting formalistic categories picked for their workability in the sense of helping courts dismiss these problematic cases instead of taking a more practical reasoning approach attuned to the realities of the workplace. As Justice Ginsburg provocatively says in Vance, the ball is once again in Congress's court to correct the error into which this court has fallen. Now, the last time Justice Ginsburg said something like this was in her dissent to the Lilly Ledbetter pay discrimination case in 2007. And within 2 years of that, a Democratic Congress passed the Lilly Ledbetter Fair Pay Act, and that was the first law signed into law by the new Democratic President Obama. This time, as Dean Carter says, this time Congress can't seem to agree on much of anything. And with the divided partisan government that we have, it's very unlikely that this Congress will take up Justice Ginsburg's challenge. But her dissents are a reminder that in our constitutional system of rights, equality rights specifically, both Congress and the court play a key role in defining a framework of rights going beyond the floor of the constitutional equality rights that our Constitution sets. Thank you.
A wonderful, wonderful panel. Let's take about 5 minutes here for any questions from the audience, and then just a few minutes. Anyone have any questions? I have one question, just a brief question. I know a lot of us have places to go, but I was looking at the promotional materials for this event, and it asked the question, is there any coherence to the court's approach? Which I'm really glad that that is not a question on my student evaluations or my performance tonight. But here, really, is there any coherence? And when I look at all of the different 6 cases, one factor I see that 3 of them were the writing for the court was Justice Kennedy, and then he was in the majority of all but one of the cases, the Perry Stanley case. So I wonder, is this, and he's known for his state rights stance, for the individual rights. Is that a common denominator, or is there something else? Maybe just a few comments to try to pull it together and see if there is some coherence or if there isn't.
Well, I can't really wrap it all in a neat bow in terms of coherence, but a couple of themes strike me cutting across these cases, and one would be the clash and really the relationship between Congress and the court and the struggle between them about equality rights. And so certainly in the Shelby case, where the court is dissing Congress's revising and beefed up record for the Voting Rights Act, and then especially in the Nassar case, where the court is, frankly, running away from the gist of the 1991 amendments and not giving Congress, a fair reading of what Congress was doing there. I think this is a constant in our system, frankly, and it does allow room for popular engagement with the meaning of equality rights through the legislative vehicle. And it's messy, and we may sometimes think it comes out wrong, but it is a feature, really, in the big picture, a great feature of our constitutional system. And a second theme that just jumps out, the whole notion of post-racialism. I see that a lot in the civil rights laws as well, and not just post-racialism, but post-sexism too, and pretty much post-civil rights in a lot of this. And I think the main things driving the two decisions I'm talking about, frankly, are the court's sense that civil rights violations don't happen so much in the modern workplace anymore. And so the Nassar case is really driven by this concern about getting rid of meritless retaliation claims, again, without giving enough deference to Congress's judgment that there's a big problem here to be solved.
I'll be brief. I think there are two. One Professor Brake already hit, which is what I'll call judicial immodesty. Contrary to that quote, was it Justice Frankfurter who said that the Supreme Court gets to go last, not because we're always right, but we're treated as right because we get to go last? The court seems to believe that its word, its definition of the constitutional meaning with regard to equality is superior normatively to those of other constitutional actors. I have some real questions about that. The second thing, though, I think is what I called in one of my articles and what I mentioned a moment ago, the court seeing itself as a protector of social cohesion, right? If you believe we have entered a post-civil rights phase, then any remedy, whether in gender, sexual orientation, or otherwise, that explicitly takes account of that simply reinforces divisiveness and threatens social cohesion. So a lot of these cases are about the expressive function of the law, to use a phrase, that the court seems to believe that it is better to simply let certain things lie than to aggravate existing tensions by redressing them.
Yeah, I mean, the only thing I would add is, to the idea of who gets to decide what's constitutional and what's not, who gets to decide what's equal and what's not. I mean, that was definitely permeating the same-sex marriage cases in terms of, okay, does the executive get to decide what's constitutional or not? In both cases, whether it was the state executive or the federal executive, or whether it's the court, and when should the court be taking it up? Definitely in the same-sex marriage cases, when you're talking about the standing issues in both cases, they came out differently. In the one case, the Dissent in the Windsor case are saying, why are you, saying that they're standing here when there's no standing in the other case? You're just trying to get there. You just want to say what you want to say about same-sex marriage. And that's essentially what Justice Scalia was criticizing the majority for. It was just, you just want to be the last word. You just want to say what you want to say and, criticize everyone else. And then the other case, the Hollingsworth case, they basically say, well, there's no standing because we don't want to go there yet and talk about whether, the state bans on same-sex marriage are unconstitutional because, that could really, upset a lot of people. And so, who gets to decide is a big question.
Wonderful, good. Well, here I get to be the last word. And what I'm going to do, because in the interest of time, is to ask for one more round of applause for our wonderful panel. Thank you so much. Although our time is concluding right here for this session formally, I hope that we continue to discuss these issues and to continue to explore what is equality and how is it defined and redefined through the law. So thank you so much for your time today on this Constitution Day. It's much appreciated.